Ladies and gentlemen, the opening of the legal year 2021 ceremony will now commence. We request those attending in person at the state courts to please rise. Please remain standing for the national anthem. For safe management reasons, you will not need to sing the national anthem. Please be seated.
All manner of persons having anything to do with the sitting of the court, draw near and give your attendance.
Mr. Attorney.
May it please Your Honours, Chief Justice, Justices of the Court of Appeal, Judges of the Appellate Division, Judges and Judicial Commissioners. The past year has been an extremely trying one for the country and no less for my chambers. It has been a real test of our fortitude, our commitment to defend and advance Singapore's interests, and our ability to adapt to unforeseen difficulties brought about by the COVID-19 virus. I'm very proud of the good work my chambers has done over the past year, which I will share with you in the course of my speech this morning. I also acknowledge that the past year has shown that we have some room to grow and improve. I will outline the measures we have undertaken as an institution to address issues which we faced and ensure that we meet the highest standards of excellence, fairness, and integrity in the years to come. My speech this morning is in three parts. First, I will talk about the critical legal support which we provided to the government throughout the COVID-19 crisis. Second, I will discuss some initiatives we have embarked on to future-proof the organization and to deal with the challenges which we faced the past year, including digitalization and workforce changes. Finally, I will share my reflections about the role we play in the criminal justice system and what I consider to be our grave and solemn duty as prosecutors. On the first point, COVID-19 has been described as the crisis of our generation. It has been said that crises bring out the best in people and in organizations. The COVID-19 crisis certainly brought out the best in AJC. While the government worked tirelessly to respond to the pandemic, we worked as one AGC to provide public agencies with crucial legal support. Once the severity and potential impact of the disease became clear, we formed a cross-divisional COVID task force in January 2020, comprising representatives from all our legal divisions. We anticipated that government would need urgent and cross-cutting legal advice and support to address a possible pandemic and its repercussions. This proved to be prescient. In the first half of 2020 alone, we received more than 1,300 COVID-related requests for advice. Almost all of these were urgent. We responded to 69% of these cases within 24 hours and 78% within 48 hours. The pace and intensity of this work were unprecedented, and I'm glad to say became true for our clients. AGC contributed to the battle against COVID on multiple fronts. First, working closely with our officers who are posted to satellite legal departments in the ministries, the task force advised the government on all aspects of its pandemic response. This included advice on establishing government quarantine facilities, implementing temperature surveillance, testing and contact tracing measures at key locations, securing our borders, and protecting trade flows to preserve essential supplies and stockpiles. We also provided critical legal support on the tapping of past reserves to finance the various COVID response budgets. We advised on the impact of COVID on government contracts and on negotiations for the procurement of possible COVID vaccines. Under acute time pressure, we worked tirelessly with agencies to craft stress tests and fine-tune the COVID-related policies through multiple iterations. No lines were drawn between law and policy as we fought alongside our clients in the trenches together. Second, we drafted major pieces of legislation in record time. This was necessary to allow the government to quickly implement new measures to control the spread of the disease, such as safe distancing measures and contingency healthcare arrangements. Legislative amendments also enabled the government to introduce moratoriums and various schemes for financial, tax, and other reliefs to sustain the economy, as well as to implement special arrangements for parliament sittings and to allow for company meetings and court hearings to be held remotely. Third, we work closely with law enforcement agencies to enforce the Infectious Diseases Act and COVID-19 related legislation strictly and swiftly. Breaches of quarantine orders, stay-home notices, circuit breaker restrictions, and safe distancing measures were quickly prosecuted or dealt with. Errant businesses were also promptly issued warnings and, in egregious cases, suspension orders. We worked on an urgent basis to assess the evidence and take quick action in all these cases to send a strong message that the government's public health measures had to be taken seriously to control virus transmission in the community. Finally, as the world grew increasingly isolated to curb the spread of the virus, it became more important than ever for Singapore to maintain our international connections. We did a significant amount of work to ensure that our COVID measures remain consistent with our international obligations. As the virus situation improved in Singapore, we also assisted in the negotiation of essential travel and air bubble arrangements to sustain economic exchanges and maintain our relevance as a hub for the region and the world. In addition to our COVID work, AGC kept the legal machinery of government running in a very different operating environment. Criminal prosecutions and urgent civil litigation matters continued during the circuit breaker period and beyond, but with many more remote hearings. Our officers adapted rapidly by learning how to present arguments and in some cases examine witnesses over Zoom. Through countless Skype meetings and emails, we maintained our usual pace of drafting and providing advice and legal representation to the government, including during the recent general elections, which presented particular difficulties due to COVID restrictions. We had to urgently advise the government on how to deal with the unique challenges and legal complexities involved in holding an election in the midst of a pandemic. In short, against all odds, we have not merely survived but excelled in the past year. I have been humbled and heartened to witness my officers coming together to stand shoulder to shoulder with the entire public service, both to manage this unprecedented crisis and also to keep essential operations running in new and innovative ways. We were tested to the limit and have emerged stronger, more resilient, and more united as a chambers. Next, I would like to talk about some initiatives which we have introduced to equip AGC and the broader public service to meet current and future challenges and opportunities. While COVID-19 may have cast the longest shadow, it was only one of many developments which have the potential to fundamentally alter our legal landscape. As an institution, we cannot take our eyes off these other driving forces. There will be life after COVID, and AGC is preparing to meet it by strengthening our existing capabilities and strategizing for the longer term. Allow me to focus on just two key aspects. First, the push for digital transformation. You may have seen the famous meme depicting a multiple choice survey question. Question is, who led the digital transformation of your company? The answer options are first, the Chief Executive Officer, next, the Chief Technology Officer, and finally, COVID-19. Needless to say, the last choice is the one that is selected. While COVID has certainly accelerated AGC's digital transformation, this was only possible because we had already laid the groundwork in the last few years by moving large portions of our work online and integrating new technologies. This enabled us to accomplish the transition to working remotely without any major disruptions and even with increased productivity. This is not the end, but beginning. We are just scraping the surface of how much we can achieve with the proper technological tools. This year, we will be rolling out a number of digital innovations to benefit the government and the wider public. An example of this is legal automation. Several AGC officers have been learning to utilize software which can be used to code and automate legal processes, like contract drafting for government procurement. AGC is currently developing a contract drafting application which will save public officers considerable time that would otherwise be expended on amending templates manually. As the application will be developed by our own lawyers, the quality and consistency of the documentation it produces will also be improved. A recent pilot of a similar application with selected public agencies was well received, and we now plan to expand this across the whole of government. This is part of our vision to upscale our service delivery. By the first quarter of this year, we plan to launch the Legislation Code System, which is a computer-readable reference protocol for legislation tagging. Every act, every section, every subsection will have a unique identifier code, paving the way for enterprise searching of specific provisions across case databases. Parliamentary reports, journal articles, and even press releases will be tagged to these pieces of legislation. While we intend to first roll this out to government systems, legislation codes will potentially be made available to private enterprises in the future to facilitate improvements in regulatory compliance and promote the development of citizen-centric digital apps in the legal sector. AGC is also collaborating with other agencies to enhance digitalization across the whole of government. We have plans to fully integrate our internal criminal case management systems with those upstream at the enforcement agencies and also downstream at the courts and prisons. This will allow matters to move through the criminal justice system more seamlessly and also yield end-to-end digital insights. Digital innovation will be complemented by workforce transformation. We're heading into a very different world, and the demands on AGC are rapidly increasing. To ensure that our existing manpower is optimized to meet these challenges, we will be undertaking a major reorganization of our executive workforce. Our clients and the public may be familiar with the work that our lawyers do, but behind them is an equally dedicated core of executives who provide indispensable support to AGC. I would like to take this opportunity to recognize and commend them for their contributions. The planned reorganization will deepen our executives' expertise and broaden the career pathways to ensure that their professional responsibilities and development are commensurate with their ambitions, their potential, and the future demands of the organization. This brings me to my third and final theme, one that is of utmost importance. As prosecutors, we weathered our own crisis of sorts in 2020. There were several decisions that did not go our way, including Patilai, Liani, and Gobi Avidian. These are not the first high-profile acquittals in our history, and they will certainly not be the last. However, what made 2020 uniquely challenging was a sense that the public's trust in us was at stake. That is something we take extremely seriously because that trust is fundamental to our mission, and we work very hard to be worthy of it. I want to begin by assuring the public that we recognize ours as the grave and sacred duty to use our prosecutorial discretion to serve the public interests. That is the lodestar for all our prosecutors. Our motive is not to win at all costs or to secure the most convictions, but to reach just outcomes fairly. This overriding principle informs every stage of our work. As a reminder, charging decisions are made only after we are satisfied that A, there is sufficient evidence to support a reasonable prospect of conviction, and B, it is in the public interest for us to prosecute. In making this assessment, we carefully consider all available evidence, the circumstances of each case and each accused person, as well as what is fair and proportionate. Every prosecution is commenced in the genuine belief that a crime has been committed and needs to be answered for. Integrity guides our conduct of proceedings from start to end. Our assessment of evidential sufficiency and public interest is an ongoing one and continues even after a person is charged in court. If new facts and circumstances come to light which show that prosecution is no longer tenable or desirable, we will review the matter and withdraw charges as we had done in many cases before. While proceedings are underway, we take great care to comply with our disclosure obligations in fairness to the defense. At the sentencing stage, it is our established practice to highlight the most relevant precedents, even if they are unfavorable to us, so that the court may have the fullest possible assistance in arriving at the appropriate sentence. Even after a matter has been concluded, we do not oppose criminal revisions and appeals where we agree, upon review, that the outcome at first instance did not serve the public interests. Practicing these principles on a day-to-day basis is by no mean feat. My team of some 245 prosecutors assesses over 40,000 investigation papers a year. That number excludes their court appearances, which average more than 7,000 concluded matters in the Supreme Court and state courts each year. Despite the punishing load they carry, there is no question that in all these cases, my prosecutors have tried to perform their duty with integrity and to the best of their ability. But even so, I must acknowledge that there were imperfections in the past year that exposed AGC to intense scrutiny and criticism. This is not the appropriate forum for me to traverse the specifics of these cases. However, I pledge that we can and will do better too, in the words of the Chief Justice, to discharge a fundamental duty to, and I quote, to assist the court to arrive at the correct decisions as ministers of justice. These were the words made by the Chief Justice in the case of Public Prosecutor versus Wee Tiong Boo last year. We are taking concrete steps to live up to this weighty responsibility. First, we are carefully reviewing the training and guidance which our prosecutors receive. A key tenet of prosecutorial training is that all prosecutions should be guided by the public interests. Our culture must be one where prosecutors take pride in doing right, not just by victims of crime, but also by accused persons and by society. In his book, Doing Justice, A Prosecutor's Thoughts on Crime, Punishment, and the Rule of Law, former U.S. Attorney for the Southern District of New York, Preet Bharara, wrote about the constant admonition that his office lived by, and I quote, to do the right thing in the right way for the right reasons and do only that, close quotes. This must also be true of AGC. We will make greater efforts to instill these core values in every prosecutor so that they become part of the natural fabric of our work ethic. Second, in order to help prosecutors actively consider and fulfill their obligations to disclose documents to the defense, we have drawn up detailed internal guidance and held division-wide briefings to explain how these must be complied with strictly in practice. More importantly, at a deeper level, we've engaged all prosecutors in the process of reimagining our role in criminal proceedings. This goes beyond mere technical compliance with disclosure and evidential rules. Our greatest interest must lie in ensuring that a court is presented with all relevant evidence which may help it to arrive at its own determination of the truth. This overriding attitude to ensure fairness is what we must bring to bear on our conduct of all court matters. Third, in response to the lessons which we learned from the Patti-Liani case, the prosecution is working with the police on internal guidelines for first, recording investigative statements properly, and second, obtaining proper valuations of items which are the subject of property offenses. These guidelines will make our approach to these matters more principled and consistent across cases. To preserve and also enhance the public's trust in us, AGC will reinforce our efforts to demystify the inner workings of prosecution and make the criminal legal system as a whole more accessible and intelligible to the public. In my last OLY speech, I pledged that we will continue to explain the basis behind our decisions more clearly in appropriate cases. We have followed through on this commitment, and we will continue to do so. Let me give 3 examples. First, in cases which attracted widespread public interest, we have sought to articulate the basis of our decisions more clearly and to clarify any misinformation in the public sphere. In the Tower murder case, for example, in the Orchard Towers murder case, for example, we issued media releases to explain our charging and sentencing positions and to refute malicious and utterly baseless allegations of racial basis in sentencing. In Pati Liani's case, we also issued media releases to clarify the process by which the charging decision was made, so as to dispel any misconception that the complainant in that case was given special treatment or that I was somehow involved in the charging decision in view of my prior acquaintance with him. Second, my deputies and I have been taking pains to publicly explain how we arrived at our charging and sentencing positions in practice. In the first year that I took office as Attorney General, I delivered a Singapore Law Review lecture on the topic, Prosecution in the Public Interest, which discussed in detail how public interest considerations inform the exercise of prosecutorial discretion in AGC. DAG Hari Kumar also gave the keynote address at the sentencing conference in 2017, where he spoke on the prosecutor's role to assist the court in arriving at a just sentence and not a high one. More recently, one of our chief prosecutors gave an interview to the Straits Times, explaining how AGC contributes to clarity in sentencing by proposing sentencing frameworks in appropriate cases, which can help to ensure that sentences are principled, proportionate, and consistent across the board. Third, AGC is collaborating with external agencies to engage and educate the public on the intricacies of the criminal justice system. Over the past 2 years, we have partnered with Lian He Chapao on a series of articles about Singapore's legal system and our role within it, including topics like plea bargaining, gag orders, and court procedures. We are also reaching out to the public through vernacular media to make sure that every Singaporean knows that there is no preferential treatment for different races in sentencing. Just 2 weeks ago, Mothership.sg released a video interview with one of our deputy chief prosecutors, where he answered questions about prosecutorial work. We recognize that issues of criminal justice and punishment matter deeply to our community, and we will continue our efforts to help the public to engage with these issues thoughtfully and constructively. Through the initiatives I have described, we are working to address institutional gaps and provide greater accountability to the public. While we do so, I ask for understanding on the public's part. Criticisms are welcome, and we do not shy from them as long as they are fair. Not every acquittal is a sign that our prosecutors have failed in their duty as ministers of justice. Some acquittals may result precisely because we took steps which served the interests of justice but were adverse to our case. For instance, by sharing evidence with the defense. Other times, there may be changes in the evidence or to the law which we could not have anticipated. There will be cases where, at the end of the day, the evidence falls just shy of establishing all the elements of the offense. In the broader scheme, acquittals are a sign of health for the legal system. They demonstrate the judges probe the prosecution's case and apply their minds fairly and independently. More importantly, acquittals also show that AGC does not only pursue cases which are easy wins, but also cases where we truly believe that an offense has been committed and must be addressed. The case of GCK is an example of such a case. This involved a male staff member who had molested an elderly female patient in a nursing home. The case was difficult to prosecute because the victim was unfit to give evidence, so the case depended largely on the testimony of a passing eyewitness. The accused person was convicted in the state courts, but his conviction was set aside in the High Court because of evidential difficulties. The prosecution then referred a question of law, which had arisen in the case, to the Court of Appeal. Ultimately, the conviction was reinstated, and the offender was sentenced last year to 16 months imprisonment and 3 strokes of the cane. This is the case of PP versus Sicc in 2020. If we refrain from prosecuting whenever there is some risk of an acquittal, then this injustice and many others would never see the light of day. The real measure of AGC as an institution does not lie in the number of convictions we secure, but in prosecuting worthy cases fairly and upholding the public interests. We will not allow the fear of failure or of public backlash to stand in the way of this duty. Let me stress this clearly. Neither acquittals nor baseless lawsuits or actions commenced against my chambers or my prosecutors will deter us from fulfilling our mission to prosecute in the public interest. Finally, I would like to express my appreciation to the criminal bar, particularly pro bono defense lawyers. As the High Court stated in the case of Arun Kalyamurthy in 2014, and I quote, "Both the prosecution and the defense are discharging public functions in the interest of justice, but securing convictions and acquittals of criminals and innocents respectively." Close quotes. Criminal lawyers are our counterpart in the administration of justice, and we all stand to benefit from their dedication and integrity. While adversarial in form, our roles are in truth complementary. In the coming year, we will continue to keep an open line of communication with the bar through our regular lunches and dialogue sessions with representatives from the Law Society and the Criminal Legal Aid Scheme. I wish to thank the criminal bar for working alongside us towards a common vision of a fair and just society. It would be remiss of me to conclude before expressing my gratitude to all my AGC colleagues who routinely go beyond the call of duty to serve the public and safeguard our country. While our prosecution work draws the most media attention, that is just one aspect of what AGC does. The public may not be aware of the rest of the work undertaken by AGC, which is equally important. My civil cluster officers work tirelessly to draft legislation, provide legal advice to agencies, and represent Singapore's interests on the international stage. The efforts behind the scenes are just as vital to the public interest and the rule of law in Singapore, and the frequent notes of appreciation that are received from our client agencies attest to the quality and value of their work. This year, we will continue to provide timely and critical support to the government in navigating the legal headwinds to come. We will also double down on our efforts to live up to our mission as guardians of the public interests and stewards of the rule of law. That is the spirit which animates all our work, whether as public prosecutor or government legal advisor, and we're humbled and privileged to serve this higher calling. On that note, please allow me to take the opportunity to thank and congratulate former Solicitor General Kwek Minlak, who served AGC with distinction for more than 5 years before his elevation to the bench this year. Minlak did a tremendous job in helping to shape the culture at AGC into a more cohesive, client-centric, and forward-thinking one, and I have no doubt he will bring his distinctive brand of transformational thinking to the development of the law in his new role. I will miss having Minlak at AGC. I would also like to extend a warm welcome to our new Deputy Attorney General, Tai Wei Siong, who has returned to AGC after holding a number of strategic leadership positions in the public service. Wei Siong has a wealth of experience in both government and the law. With him as a key member of the leadership team, I'm certain that AGC has what it takes to meet the challenges ahead. May I also take this opportunity to congratulate, firstly, Justice Andrew Pang on his reappointment as Vice President of the Court of Appeal. Next, Justice Stephen Chong on his appointment to the International Commercial Expert Committee of the Supreme People's Court of the People's Republic of China. I would also like to congratulate Justices Belinda Ang, Wu Billy, and Quentin Low on their appointments as judges in the new Appellate Division of the High Court, and in particular, Justice Ang on her concurrent appointment as President of the Appellate Court, and Justice Low on the extension of his appointment as a High Court judge and his concurrent appointment as President of the Singapore International Commercial Court. I would like to congratulate Justices Chan Sing-on, Lee Siew Kin, and Chu Han Teck on the extension of their appointments as judges of the High Court. Also, Justices Chow Hik Ting, Andrew Ang, and Lai Siu Chu on their reappointments as senior judges of the High Court. I would like to congratulate Justices Deirdre Singh Gill and Mavis Chon on the appointments as judges of the High Court from 1st August 2020 and 12th March 2021, respectively. Next, I'll congratulate Judicial Commissioners Andrew Maniam and Philip Anthony Jaratnam on their appointments to the bench, and finally, to our 16 international judges on their reappointments to the Singapore International Commercial Court. On behalf of AGC and the legal service, I pledge the fullest support to the judiciary in the discharge of the constitutional responsibility to administer justice. It leaves me to wish Your Honours and all members of the legal community the very best for the year ahead. Thank you.
Thank you, Mr. Attorney. Mr. Vijayendran.
May it please Your Honours, Chief Justice, Justices of the Court of Appeal, Judges of the Appellate Division, Judges and Judicial Commissioners. First, I warmly welcome our overseas bar leaders who are joining us in an armchair travel for this ceremony, despite challenging time zones for some. A special acknowledgement also goes out to Chung Hwan Choi, President Law Asia, for your virtual presence. 2020 and the opening days of this year saw announcements of key extension of appointments of High Court judges and reappointments of senior judges and international judges. Justice Quentin Low receiving the Christmas gift of an extension of appointment and concurrently appointed President of the Singapore International Commercial Court. Justice Chan Sing-on extended and Justices Lee Siew Kin and Chu Han Teck to be extended. Justices Chow Hik Tin, Andrew Ang, and Lai Siu Chu reappointed as senior judges, and the reappointment of 16 international judges to the Singapore International Commercial Court, all as of 5th January. Last Monday, Justice Tan Lee Meng completed a distinguished career in the judiciary spanning 23 years. Practitioner members will look forward to him spending more time waving his magic wand during mediation sessions. At the Apex Court level, on 2nd January, Justice Andrew Pang was reappointed Vice President of the Court of Appeal. Concurrently with that reappointment, Justice Pang, together with Justices Judith Prakash, Tay Yong Kwang, and Stephen Chong, were redesignated as Justices of the Court of Appeal. Justice Belinda Ang is inaugural President, and Justices Wu Bi Lee and Quentin Low are judges of the newly constituted Appellate Division of the High Court, an interesting structural development of our Supreme Court. There have also been a spate of stellar appointments to the bench from both public and private sector. Andre Maniam SC appointed Judicial Commissioner on 4th May last year. Judicial Commissioner Deirdre Singh Gill appointed Judge on 1st August last year. Solicitor General Kwek Minlak SC and Philip Jaratnam SC appointed Judicial Commissioners on 4th January, and Judicial Commissioner Mavis Chon to be appointed High Court Judge on 12th March. On behalf of my counsel, I extend my best and warmest wishes to the bench appointees. They, like other serving members of your honest judiciary, are drawn from the cream of the crop in legal service and private practice. As John Paul Warren said, cream always rises to the top. If you turn back the clock to January last year, I shared many 2020 visions during my opening of legal year speech. But in the short space of a month, we were detrimentally impacted by COVID-19. That a microscopic virus, measurable in nanometers, could inflict untold, unimaginable harm on health, work life, economy, social life, and our overall lives was not within our foreseeable contemplation as a harbinger of a new decade. I was nearly tempted to reread last year's speech for this year, given our annus horribilis in 2020 and the reset button in 2021. The Law Society Council did not sit back slumped on our chairs in despair in the wake of the greatest crisis of our generation. We adopted a five-fold strategy to combat the crisis: stimulate resilience among law firm practices and practitioners, strategic intervention to assist members, strict austerity on organizational costs, accelerated technology adoption to cope with office work disruption, and incubating innovations as pilot projects to benefit the profession. I shall elaborate on the specific tactical solutions deployed to achieve these strategic aims and some thoughts on the way forward in this speech. 21 in many jurisdictions is the legal age of maturity. As we start the 21st year of the new millennium, I discern a maturity in the legal profession and administration of justice. Part of that maturity comes from a newfound resilience. The cost to the Law Society for our extraordinary relief package exceeded $2.3 million. Extraordinary times called for extraordinary measures. While coming at a painful price inflicted on the Society's coffers, these financial strategic intervention steps were imperative to help our profession. Some law firms faced existential questions. I'm grateful for the financial prudence and wisdom of past councils that left us in a healthy state to help lawyers meaningfully weather the adverse impact of the COVID-19 crisis. As we emerge from the worst of the pandemic, having moved into phase 3 a fortnight ago, the Law Society will carefully calibrate our approach to achieve the twin goals of strategic intervention and catalyzing resilience. A strong law society leads to a strong rule of law and strong access to justice for society generally. On strategic intervention, the Law Society remains committed to extending a helping hand to vulnerable members and groups. Discounted memberships may be as rare as hen's teeth, but it was exceptionally appropriate and proportionate last year. Computationally, we arrived at 3 months, 2 months of circuit breaker and another month for the aftermath for that discounted membership. Yet a permanent crutch of a dependency mindset is unhelpful to practitioner, profession, and public in building resilience. The Law Society will consider stimulating recovery by offering some services gratis. For starters, we will continue to waive advertising fees for basic listings on the careers portal for all Singapore law firms for a 6-month period beginning today. We have seen a remarkable maturation of court hearings. Through judicial leadership by Your Honour Chief Justice, innovative online court hearings involving Zoom technology are living reality. We have these means only because, first, our judges are tech-savvy, and secondly, the state-of-the-art of today's technology. In turn, we are appreciative that because of the bench provision of essential services of access to justice throughout the circuit breaker period and beyond, Singapore-based litigators are in business and their law firms classified as essential service providers. The state courts rolled out an interesting pilot involving asynchronous court hearings via the use of email directions. That was well received by the bar, especially the personal injuries and property damage bar. For Zoom court hearings, counsel and courts need to be sensitized to the 1970 Hague Convention on Taking of Evidence Abroad in Civil or Commercial Matters. The bar will explore the feasibility of developing agreed protocols between counsel for Zoom hearings going forward, including on ethical safeguards such as no coaching, no communication, and no cheat sheet while witnesses give evidence. Additionally, where there have already been credible opinions sourced for court hearings confirming the permissibility of video-linked evidence taken from different jurisdictions, there is no need to reinvent the wheel for future cases. The attendant costs of obtaining fresh confirmations could prove a bane for litigants with limited means. I suggest that a list of green-lighted jurisdictions be curated and updated from time to time to reflect changes in the state's stance on video-linked testimony from last opinion date. Part of the maturing role of the Law Society vis-à-vis broader society is our legal fact-check facility cited on the public section of the Law Society's website. This serves the public by providing reliable and accurate legal fact-check answers to general legal questions arising out of current news reports. Last year, among others, we shared primers on gag orders, terrorism financing laws, and remedies in harassment cases. In last year's speech, I said, as a valuable voice in society, the Law Society will continue to speak up without fear or favor in the courtroom, corridors of power, and community consistent with law. An opportunity to be guardians of justice arose unexpectedly last year. A letter written by a former UK City of London Law Society chief, published in the South China Morning Post in end November, contained an extraordinary attack on rule of law, our courts, and the Law Society. We authored a response to defend against the triple onslaught. We were constrained to do so to maintain the repute, standing, and integrity of our institutions. The Law Society will continue to speak out firmly and respectfully. In tandem with that, we renew our clarion call for the government to unshackle the fetters of Section 38(1)(c) Legal Profession Act on the Law Society via legislative amendment. The Law Society can continue to be an impactful and independent voice in society. Society and our society has matured. We sustained a spotlight on the economic health of law practitioners and practices in 2020. The Economic Action Council, spearheaded by former President Teo Shen Yi SC and myself, reappraised our shortlisted solutions in the light of COVID-19. We paused to re-diagnose the impact of the pandemic on the profession. The playbook needed to be rewritten. We weighed new potential solutions for the new economically vulnerable. Pursuant to that re-diagnosis, the Law Society conducted a member survey at the end of the circuit breaker period. Our threefold aim of the COVID-19 impact survey was to obtain feedback on 1, the pandemic impact on economic health of Singapore law firms, 2, the experience of individual members working from home, or WFH, and 3, the mental well-being of members. Despite the short 2-week response turnaround, the survey garnered a record 777 responses, representative of different lawyers' seniority and firm sizes. The survey feedback became fresh food for thought for the Economic Action Council. Calling a virtual town hall, we discerned from the feedback collated that among the low-hanging fruits to roll out were ramping up mediation services and catalyzing business development. The survey also revealed a strong appetite for innovation. Close to half the respondents expressed interest in online legal marketplace platforms if regulatorily permitted. By removing roadblocks, we could unlock innovation and creativity in providing legal services and new cylinders of growth and revenue for individual practices. We then did a deeper dive via further survey on the nuanced offerings of alternative legal structures, for example, bi-disciplinary practices and independent legal service startups using disruptive technology. We will study the results carefully before making recommendations on regulatory pain points to remove and law reform points to advocate. Newly elected Vice President Jason Chan SC will spearhead thought leadership on multi- or bi-disciplinary practices. We will also organize a virtual business development day with active council participation in the first half of the year to cover topics such as the blue ocean areas of law, tech adoption, and leveraging on social media for marketing. The market value of a lawyer is inextricably linked with the non-negotiable calling card of integrity and ethical propriety. The Law Society is finalizing a sequel to the 2019 Professional Ethics Digest to be released this quarter. This will contain additional relevant illustrations of the Professional Conduct Rules 2015, drawn from an anonymized version of members' guidance given by the Advisory Committee of the Professional Conduct Council. Separately, taking a leaf from the Canadian Bar Association's work, we will develop a practical conflict of interest toolkit for members this year. To continue to brand the Singapore lawyer, the Law Society launched a microsite in February last year. But to be brutally honest, rather than focusing on fluff, every lawyer needs to think about his or her own unique value proposition in our ecosystem. A helpful line of inquiry is if you close your practice down today, which client or practice will miss you? An exemplar at the bar was the judicial giant in law, the late Dr. Gopalan Raman, who sadly left us last month. The passing of this guru of wills, probate and administration leaves a gaping void in probate practice on both sides of the causeway. Our market value can never be parochial. Vietnam was the target destination for the next edition of Lawyers Go Global at the end of February 2020 until the pandemic hit. So we postponed our mission, but Vietnam remains top of our go-to list. We will also nurture an ASEAN focus this year. Our International Relations Department creatively developed a virtual networking event with our valuable partners, the Guangdong Lawyers Association. We can utilize tech to keep links and connections warm and maintain our value despite lack of travel and going forward even through hybrid events. Mediation is a massive piece. We intentionally built more feeders into the Law Society Mediation Services, or LSMS. One example comes courtesy of invaluable input by our Conveyancing Practice Committee. Parties to conveyancing contracts are encouraged to resolve disputes through mediation pursuant to Condition 16 of the new Law Society Conditions of Sale 2020. Our newly formed mediation committee made a flying start and is collaborating with both the Tripartite Alliance for Dispute Management and the Family Justice Courts to build more pipelines. We will also pivot on companies requiring support in COVID-19 legislated situations. Consistent with our strategic aim of test trialing innovations, we introduced online mediation for our LSMS. This proved pragmatic, feasible, and leveled the playing field where one party is overseas. A successful experiment, we saw a steady growth with over 30 LSMS cases last year, despite the disruption. The COVID-19 Impact Survey revealed key findings on the WFH experiences of members. The majority of the respondents were WFH by the end of circuit breaker. The top WFH advantages were time savings in commuting and greater schedule flexibility. The top WFH challenges were blurred lines between work and leisure and reduced social interaction with colleagues and clients. And the top new measures law firms took to support WFH were redesigning legal and practice processes and workflows and purchasing and deploying additional hardware and software. The Smart Law Guild membership in the Law Society comprised early movers such as Smart Law certified law firms and successful applicants of past and present technology support schemes. To date, over 290 law firms have been smart enough to adopt progressive technologies to keep themselves at the forefront of productivity and innovation. To facilitate the ease of navigating through the myriad of government support schemes, we launched our Gov Assistance Assessment Tool for members. The online self-assessment tool enables members to assess their firm's eligibility for and entitlement to the government support schemes, including for hiring, flexible work arrangements, financing loans, technology and innovation, and building business capability. Service delivery also applies to our CPD offerings. An important feedback shared during the COVID-19 impact survey was that most members considered free or subsidized CPD activities to be the most helpful support. Attuning to the profession's need and a strategic intervention, we waived registration fees for all CPD webinars held in the second half of last year for all Law Society members. Council 2021 will seriously study the application of a similar waiver this year after we review such hopeful help holistically. Our webinars saw record numbers, understandably so, given the sheer practicality. Streams of information, knowledge, and understanding reached out to lawyers so long as they had a laptop, notebook, personal computer, or smartphone. Tech is a great leveler and enables a greater inclusiveness across different demographics, including those facing physical or mental disabilities. Our valuable partner, the Ministry of Law, has been in constructive dialogue with the Law Society on a technology platform in the pipeline. We see this as a potentially promising initiative to support law firms to effectively plug and play in technology solutions adoption. We await the Ministry's upcoming announcement on this with eager anticipation. Mentoring remains an important theme this year. An example is our marquee event, the Litigation Conference Workshop, postponed to April this year. Hands-off last year, but in the hands-on edition this year, participants, especially junior advocates, can master courtcraft and advocacy principally through experience-based pedagogy. This will be our first ever hybrid CPD event. It is a truism that advocacy is often caught, not taught. We hope to collaborate with the Singapore Academy of Law to mentor the junior bar on advocacy. Bullying and harassment are the polar opposite of mentorship. On 9 October last year, we organized a pledge signing ceremony to signal a strong stand to combat the hidden scourge of workplace bullying and harassment. 21 law firms representing among the biggest employers in the legal profession joined the Law Society in pledging to ensure that law firm staff and colleagues are treated with courtesy, respect, dignity, and fairness. The aim? Promote and maintain professionalism, respect human dignity, and respect the inviolability of every employee's person and privacy. By signing the pledge, the signatories committed to implementing the Law Society's recommendations to liberate the work environment from the toxic culture of bullying and harassment. These include availing or accessing Law Society's Workplace Harassment Resource Guide to all staff and ensuring appropriate training for senior management and executive law firm leadership. We will organize another signature event cum webinar this year. Mentoring also applies to our female talent. Our Women in Practice Committee issued a landmark report on gender diversity in the legal profession. As I shared during the launch of that report, the big picture question is how to optimally harness the talent and better protect our estimated 46% of female legal professionals. Leveling the playing field is a thoughtful, thorough, nuanced, and balanced report that provides some insights that may lead us to answer that question. All of us, without exception, have benefited from mentorship. When the mentored become the mentors, we also attain maturity. Our relational mentorship program featuring senior-junior mentorship will continue to be a cornerstone. Prac Mentor for guidance on specialist areas of law and Career Path to guide young practitioners on career-related issues will complete the trio of mentorship services for our junior bar. We were especially concerned about members' mental health. Mental health is distinct from mental illness. Our May survey revealed that about 27% of our members experience moderate to severe mental well-being issues. Our Practice Well portal functions as a repository for relevant articles for better self-awareness and self-care. We continue to combat invisible enemies that assault our mental well-being, including extraordinary stresses, anxieties, and fears. Last year, Law Care, our pastoral care scheme, saw even more practitioners receive confidential professional counseling paid by the Law Society. We will enhance the Law Care scheme by appointing an additional counseling service center. Nicholas Au is helping to facilitate a support group for those battling mental health issues. Separately, Susan De Silva is championing well-being and wellness for the profession. We will do more to boost psychological resilience. Multi-stresses cause mental health issues. An acute stress point we experienced last year was the sad bereavement of brothers and sisters-in-law, some of whom we could not bid farewell to. We organized a virtual remembrance on 14 August to grieve 8 lawyers passing on in the first half of 2020. This was an outlet to say goodbye, remember the lawyers, and honor their legacies. We will organize another virtual remembrance this year as a memorial to the departed. As we recover, stay resilient, and rebound, let us keep in mind Winston Churchill's famous quote, "Never let a good crisis go to waste." For many of us, 2020 has been a time to introspect. Beyond maturity, market value, or mentorship, the holy grail is to find meaning and fulfillment in our practice and lives. Part of that comes when we give unreservedly in pro bono to the undeservedly downtrodden in society. Our pro bono arm continues to discern who are the new vulnerable and the most vulnerable, even as we phase out of the COVID-19 pandemic. We will target relevant services to prevent chronic access to justice issues becoming acute access to justice issues. Martin Luther King Jr. said, "Injustice anywhere is a threat to justice everywhere." The biggest dangers in both a pandemic and post-pandemic afflicted society are new injustices. We learned beneficial lessons on access to justice last year. Our legal clinics continued seamlessly, service as usual, via online counseling. Apart from reducing travel time for counselor and counselee, in some cases, counselees felt more psychologically safe and confident to share their narrative in personal law and family law matters. Online service delivery platforms for pro bono are the way of the future. There was exceptional media coverage last year on the cause celeb of the Party Liani case and the spike in local COVID-19 transmissions of foreign worker dormitories. Our Law Society Pro Bono Services has a fledgling initiative to stream justice to the relevant indigent migrant worker community. We are building a digital pathway for access to justice to the foreign worker dormitories. If we build this well, marginalized individuals will come. Another important initiative for the Law Society was launching the Compassion Fund. The Law Society helped set up and administer the LawSoc SPF Foundation Compassion Fund to offer one-off financial aid and referral support to lawyers or staff in law firms. The touchstone is whether that individual has faced sudden and unexpected personal or family adversity, directly or indirectly due to the COVID-19 pandemic. Various members of the legal profession and your honest judiciary responded enthusiastically to donate generously towards the Compassion Fund. We are deeply appreciative. As I shared in my appeal letter last year, this is a pioneering effort by the legal profession, of the legal profession, and for the legal profession. Charity begins at home and begins at our home in the Law Society. We will disburse more of such aid this upcoming year. Another area of meaning is relational connectedness at a time of isolation and separation. The Law Society innovated to connect and engage with members by sharing experiences and providing peer support. During the circuit breaker period and thereafter, we organized regular virtual huddle sessions focusing on practitioner-oriented topics, attracting at times more than 100 participants. In the pithy and eloquent words of Philip Jerednam SC, as he then was, in his C.C. Tan Award acceptance speech on the last day of the last year, a profession united in our common calling is better able to perform its social role in support of justice and the rule of law. Part of our meaning and fulfillment involves seeing the world with a new lens. As we start a new 2021, hindsight has given us a 2020 vision. This involved the simple: counting our blessings, empathy and solidarity with the suffering, achieving the elusive work-life balance while we WFH. The 2020 vision also led us to the profound: access to justice using innovations such as Zoom court hearings, asynchronous hearings, and online mediation. Such experiences took us all outside our comfort zone, but through it all, we became closer while keeping a safe distance, more relationally connected despite our isolation, unlocked in spirit even if kept in semi-lockdown during the circuit breaker, and finally, establishing a new normal while positioning for the next normal. More so than at any prior time in our history, we share the aspirations of stakeholders in administration of justice to unite as we collectively reform and transform the legal profession. We envision lawyers meaningfully practicing law with compassion, dignity, enthusiasm, and as a force for good in society. Together with Vice Presidents Lisa Sam and Jason Chan SC and Treasurer Paul Tan, this council pledges to do our utmost to promote justice with honor and compassion. In closing, may I once again assure Your Honor of the Bar's unwavering support for you and your colleagues in the judiciary. I reaffirm the Law Society's continued commitment jointly with the Attorney General's chambers to sustain efficient and effective administration of justice in all causes coming before your courts. May I extend to Your Honor, Chief Justice, all members of the judiciary, the Minister for Law, Second Minister for Law, and the Attorney General, the Bar's warm wishes and prayers for good health, multifaceted wisdom, great strength, continuing grace, and remarkable fortitude for the year ahead that we hope and pray will be better than the one that preceded us.
Thank you, Mr. Vijayendran. Mr. Attorney, Mr. Vijayendran, honored guests, members of the Bar, ladies and gentlemen. On behalf of the judiciary, I'm delighted to welcome you to the opening of this legal year. I'm very grateful to all of you, including those from abroad, for taking the time to join us for today's proceedings by way of video conference. The opening of this legal year is historic in two senses at least. First, this marks the first time the opening of the legal year is being hosted in the premises of the state courts. Second, these proceedings, in common with many court hearings this past year, are being conducted using an internet-based remote conferencing platform. As routine as this might seem today, it would have been simply inconceivable just a year ago. This is a sign of the far-reaching effects of the COVID-19 pandemic on nearly every aspect of our personal and professional lives. Over the past year, we have all had to adapt rapidly in order to contend with the challenges foisted upon us by the pandemic. Amidst our collective efforts to cope with this, we were also confronted with a case that both of you, Mr. Attorney and Mr. Vijayendran, have spoken of, that seemed to challenge the foundations of our criminal justice system. As we look back on all this, I think it can safely be said that all of us have had a challenging year, and the outlook is likely to remain somewhat difficult for the immediate future. But it is precisely in such times that we should re-examine our long-held assumptions, renew our search for better and more robust ways to carry out the vital work of administering justice, and reimagine our future. And so this morning, I intend principally to share some reflections from the perspective of the judiciary on some of the issues that we have had to contend with this past year. Let me begin, though, with the customary recap of the changes to the bench since the opening of the last legal year. First, we welcomed to the bench Judicial Commissioner Andre Maniam in May 2020 and Judicial Commissioners Philip Anthony Jeyaretnam and Kwek Minlak just a week ago. They bring with them a wealth of experience covering a broad range of areas. In addition, Justice Dida Singh Gill was appointed a judge of the High Court in August 2020, and in March this year, Judicial Commissioner Mavis Chon will be similarly appointed. Second, the legislative reforms to the appellate structure in the Supreme Court, primarily involving the establishment of the appellate division of the High Court, entered into force on 2nd January 2021. With this, Justice Andrew Pang was reappointed as Vice President of the Court of Appeal, and together with Justices Judith Prakash, Tae Yong Kwang, and Stephen Chong, have been redesignated as Justices of the Court of Appeal. Justices Belinda Ang, Woo Bee Lee, and Quentin Loh have been appointed as the first judges of the Appellate Division, with Justice Ang being appointed as its first president, and Justice Loh, who has been the judge in charge of the Singapore International Commercial Court since 2017, was appointed its president last December. Finally, with Justice Belinda Ang's move to the Appellate Division, I have appointed Justice Sicc Symposium to serve as the judge in charge of the General Division of the High Court. We have retained the expertise of Justices Chu Han Teck, Chan Seng On, and Lee Siew Kin, who have been or will be reappointed as judges of the High Court for one-year terms. We've also retained the deep experience of three senior judges, Justices Chow Hik Tin, Andrew Ang, and Lai Siu Chu. Justice Chow has been reappointed for a two-year term, while Justices Ang and Lai have each been reappointed for a one-year term. Finally, I'm pleased to announce the reappointment of 16 of our international judges. I extend my heartiest congratulations to each of my colleagues on their respective appointments and reappointments. Collectively, these steps will boost the expertise, diversity, and strength of the bench while also renewing our ranks. Finally, I thank Justice Tan Lee Meng, whose term as a senior judge concluded on 4th January this year. I'm deeply grateful for his contributions to the judiciary over the course of almost a quarter of a century. I would also like to record my appreciation to Justice Yasuhei Taniguchi, whose term of office as an international judge ended on 4th January this year. Let me turn to criminal justice, which has occupied much attention this past year. Over the years, the legislative framework governing the conduct of criminal proceedings has evolved towards securing a better balance between the respective interests of the prosecution and the defense. But in a common law system, even the best legislative framework draws life from court judgments. And this is reflected in several significant judgments issued this past year. Securing fairness is crucial to the attainment of justice and order in society. Justice has been described as the first virtue of social institutions. In every society, the cry for justice is primeval and extends both to what is done and what is seen to be done. At its core, the essence of justice is rooted in the innate human instinct for fairness. The courts do not carry the burden of administering justice alone and are, as you, Mr. Attorney, have mentioned, assisted by the prosecution serving as ministers of justice to assist the court in establishing the truth, and also by the bar, which has a particular responsibility to maintain the highest professional standards in criminal matters where life and liberty are at stake. Mr. Vijayendran, you mentioned the work of the pro bono services arm of the Law Society. Sole proprietors and practitioners in the smaller firms are in fact disproportionately represented in the ranks of those who perform pro bono services. Their fidelity in and commitment to promoting access to justice for all is both commendable and inspiring. I have often highlighted and acclaimed the efforts of the many practitioners who undertake to provide representation and assistance to those in need without expectation of significant or indeed any remuneration. This is a shining example of the best the bar has to offer. But let me reiterate that every counsel, whether for the prosecution or the defense, are first officers of the court and obliged, therefore, always to come well prepared and to assist the court with great diligence in the pursuit of truth and the dispensation of justice. Within this overarching framework, each institutional player has specific and complementary responsibilities to uphold the integrity of the system. And at the individual level, each of us must approach our calling to administer justice with devotion and a sincere openness to identifying and remedying any shortcomings. Mr. Attorney, you have spoken on measures being taken in your chambers, including enhancing training and developing internal guidelines to improve investigative work processes. What then of the courts? Because of the weight of judicial office, the quest for a sound system of justice begins with the selection as judges and judicial officers of women and men who have the appropriate temperament, ability, and integrity, and a firm and unwavering commitment to do their utmost in discharging that office. But even so, judges are not infallible. That is precisely why virtually all judicial structures in the world incorporate a system of corrective procedures, such as appeals, so that where something might have gone amiss at first instance, there is the opportunity to set it right. Justice Chan Seng-on was confronted with that responsibility in Ms. Pati Liani's case. He carefully scrutinized the evidence that had been led, the arguments that were advanced before him, and the judgment of the trial court, and arrived at his decision for reasons that he explained in considerable detail. Judges are held accountable by and through their judgments, and his speaks eloquently of how and why he came to his conclusions based on the evidence and the arguments that were before him. As the Minister for Law observed in his statement to Parliament, this was, in fact, a classic illustration of how the rule of law operates in Singapore. As the Minister put it, before the court, all are equal and justice is administered according to the facts and the law as seen by the court. But we must constantly look beyond the fact that we have corrective court procedures that work well. Thus, we too have been working on enhancing the training and development programs for judges and judicial officers over the course of recent years. The Singapore Judicial College, which has grown from strength to strength since its founding in 2015, is now an integral part of the judiciary, running a busy and ever-growing calendar of curated programs. It has been developing a judicial competency framework, which will help us to identify and enhance training needs in the necessary competencies at different stages of each officer's career. We are also increasing the opportunities for High Court judges to mentor judicial officers in the state and the family justice courts. In addition, I have established a cross-court knowledge management office overseen by Justice Sicc, which will facilitate the sharing of knowledge and best practices across the entire judiciary. But in the drive always to strive to do ever better, it is important not to overlook the commendable efforts of those who have devoted themselves to the pursuit of justice. Let me make 3 points in this regard. First, judges and prosecutors serve no commercial interest. The only interest they serve is to do right by the law. This is a calling of service to society, the proper ordering of which rests on it. Second, the oath that every judge takes when assuming office is a solemn personal undertaking to faithfully discharge one's judicial duties and to do right to all manner of people without fear or favor, affection or ill will, to the best of one's ability. The oath is a sacred reminder of the responsibilities that we have each been entrusted with, and for the sake of which we individually commit to discharging our duties with utmost resolve, diligence, and integrity. Third, it has been a decade since I have served at or near the apex of the Legal Service Commission, and in that capacity I have had the opportunity to see firsthand the commitment of our legal service officers. Let me say that it has been a source of immense pride and satisfaction that our legal service officers are, in the main, outstanding public servants who give their very best and are extremely well regarded as professionals by their counterparts both locally and abroad. This is as it should be because of the nature of the responsibilities we place on their shoulders. Let me focus for a moment on the state courts, which have done outstanding work over the years. The state courts serve as the gateway to the justice system for most litigants in Singapore. Because of this, and to ensure that they remain responsive to the needs of users, we conduct surveys regularly to gauge the confidence of our users in the process and the quality of our services. These have been overwhelmingly positive. In the most recent survey, 100% of the respondents agreed that the state courts administer justice fairly, regardless of race, language, or religion. 99% agreed that the state courts dispense justice independently according to the law, and 96% agreed that the state courts are efficient and deal with cases in a timely manner. These are extremely encouraging and cohere with our sense that vital public institutions in Singapore do seek to do their honest best. This is not something that just happened, but is a legacy that rests on the foundations painstakingly laid by our founding Prime Minister, Mr. Lee Kuan Yew, and his colleagues, and has been safeguarded and built upon by generations of public servants for more than half a century. These achievements are even more remarkable when seen in the light of the tremendous caseload cleared by the state courts. In 2019, close to 110,000 cases from the Criminal Justice, Civil Justice, and Community Justice and Tribunals Division were attended to by 91 judicial officers, which gives us a sense of the considerable workload and responsibility that they shoulder. Over the last 6 decades, our nation has distinguished herself by her uncompromising fidelity to the rule of law. This has been possible because the courts are respected by the government and by the people. This is important because the courts are the means by which we as a society have agreed our disputes and differences will be resolved. We may harbor strong views about a given case, but when all is said and done, it goes without saying that we must respect the final judicial outcome, because whether or not one agrees with a decision, the process that culminates in it affords us the best means we have for resolving our differences in a way that is fair, honest, and conduces to orderly relations. That is precisely why, in his statement to Parliament, the Minister for Law emphasized time and again that the judgment of the High Court in Ms. Pati Liani's case is final, and that it was neither possible nor his intention in any way to reopen or question that decision. That is also why, as you, Mr. Vijayendran, have noted, the Law Society acted to defend our courts and the rule of law in response to a letter carried in a foreign newspaper. The regard for and trust in the courts that the government, the Law Society, and the vast majority of Singaporeans have is something I can only describe as extremely precious. It helps our society function well, even if we differ on specific issues. For the same reason, it is imperative that one not rush to judgment and condemn errors in the judicial process as suggestive of bad faith or impropriety. Where there is reason to think that there might have been misconduct, steps will be taken in accordance with the applicable processes, and these must be allowed to take their course. Premature criticism and imputations of bad faith are not only unhelpful, but can be antithetical to due process. They undermine unfairly public trust and confidence in the very institutions that are fundamental to the rule of law. Let me turn to the post-pandemic legal landscape and make some observations on what the future may hold for the profession and the judiciary. Before that, let me briefly outline some aspects of how we actually dealt with what we were confronted with last year. Here, I want first to express my deepest appreciation to the Bar, the Attorney General's Chambers, and all stakeholders for adapting very swiftly in the face of continually and rapidly evolving circumstances as we strive to cope with the demands arising from the pandemic. At each stage of planning and responding to the pandemic, we consulted the Law Society and the Attorney General's chambers. It was only by working together and with the support of the government in passing the necessary enabling legislation that we, collectively, succeeded in meeting the initial challenge of maintaining safe and effective access to justice amidst the pandemic. The circuit breaker resulted in the vacation of many hearings, save those that were essential and urgent. As a result, the Court of Appeal lost 19 and a half hearing dates, while the High Court judges and registrars lost 694 hearing days. All cases were promptly refixed for hearing, and many have already been substantively disposed of. In the family justice courts, there was an estimated loss of 588 hearing days, but all held over hearings have been refixed and were commenced by November 2020. In the state courts, 2,033 hearing days were lost as a result of the vacation of hearings during the circuit breaker period. Nevertheless, with the exception of a very small handful of cases which have yet to be fixed for hearings, cases that were held back by the circuit breaker have either been fixed for hearing or already substantively disposed of. I am deeply grateful to the court users, the bar, the Attorney General's chambers, the judges, judicial officers, court administrators, and staff, who all worked extremely hard to help us complete the past year without building up a new backlog of cases. Let me turn to what I think lies ahead, and I make three broad observations. First, the pandemic has been a watershed in the partnership between justice and technology, and it is imperative that we ride this wave, reimagine our processes, and harness the power and potential of technology. The pace with which the courts and the profession successfully pivoted to remote hearings demonstrates that we can leverage technology to optimize our processes. In this connection, I'm delighted to announce that the Judiciary and the Singapore Academy of Law are working closely with the Ministry of Law on various initiatives outlined in the Technology and Innovation Roadmap launched in October last year. The roadmap outlines the ministry's plans to promote innovation and technology adoption and development in Singapore's legal services sector over the next decade. This includes an initiative which SAL will launch this year to enhance LawNet, thus helping law firms digitalize and increase productivity through the greater use of technology as an essential tool in legal work. This will complement the ministry's efforts to provide a technology platform for the legal services sector, which the ministry will announce soon. In line with this, the next generation LawNet will offer improved search algorithms and personalized features for better research productivity. It will, over the next 5 years or so, also progressively provide regional legal content to support the profession's regionalization efforts. Of course, even as we embrace and explore the greater use of technology, we must remain keenly sensitive to the needs of court users who are less technologically equipped or inclined, and ensure that technology is an enabler rather than an impediment. We have been conscientious in adopting measures to assist court users on the conduct of remote hearings through the publication of detailed guides and affording litigants in person the option of having their matters heard physically where possible. But we can go further. Thus, we are re-examining how court processes can further be simplified and how information can be channeled to better serve the public. I highlight a few examples. First, the Supreme Court the family justice courts and the state courts are working on a single website of the Singapore judiciary to assist the public in navigating information relating to all our courts. Second, a new e-service for simplified track divorce applications has been created to assist litigants in person. The number of litigants in person in family justice makes this an essential next step. Third, the courts are also working with the Singapore Academy of Law on a motor accident outcome simulator, which will aid the parties assess the possible attribution of responsibility and damages in motor accident cases. Let me turn to my second observation, which concerns the qualities that the profession and the judiciary will need if we are to embrace the transformative potential of technology. Multidisciplinary teams coming together to improve legal services, for example, lawyers working with data scientists and artificial intelligence specialists, may become the norm. Lawyers will have to learn to collaborate effectively across disciplines and develop capabilities in systems thinking so that they can acquire an understanding of how technology can be used to enhance their work. The pandemic has shown that change can sometimes be forced upon us, and it can be dangerous and uncontrolled if we are ill-prepared to adapt. I therefore urge all law firms to invest in the upskilling of lawyers and staff. SAL, with the support of the Ministry of Law and the Singapore Institute of Legal Education, will launch the Lifted LinkedIn Learning Pathways, a Skills Future Credit eligible program which will comprise curated online, on-demand learning from LinkedIn's courses and package these with original content by SAL and its partners. These are useful resources which law firms should take advantage of. Likewise, our law schools and continuing education frameworks must provide firm foundations to enable the profession to be prepared to harness the transformative potential of technology and to ensure that we are turning out professionals with the sort of skills and knowledge that will be needed in the coming decades. I have been in discussions with the ministers for law and for education, as well as the deans of our law schools, to address these issues, and those conversations will continue. My third observation is that the economic impact of the pandemic will further accentuate the need for peace building and a shift towards dispute avoidance and containment mechanisms. As the strain of the economic fallout brought about by the pandemic continues to manifest, the current system of adjudication will have to evolve in order to ensure that justice remains accessible. In this connection, I previously suggested that a system of justice that has at its core values of peace building and proportionality is one that will provide effective and accessible justice by reducing costs and promoting the repair of broken relationships and the reinforcement of existing ones. The current system of adjudication may have to adjust to meet the likely increased demand for complementary or alternative dispute resolution processes, as well as the reality that there will be more litigants navigating the court system without legal representation or advice. This may require us to start thinking beyond a purely adversarial winner-takes-all approach in relation to legal services in some areas. The potential for ADR processes, which you, Mr. Vijayendran, have touched on, can be seen, for example, in the SG United Mediation Initiative launched by the Supreme Court in collaboration with the Singapore Mediation Centre last year. Suitable cases were referred to SMC for mediation at no charge to the parties. As at 31st December 2020, mediation was completed for 97 cases, and of these, 39, or about 40%, were successfully settled. This resulted in a saving of more than 252 trial days that would otherwise have had to be expended in the High Court. I'm grateful to the SMC and their volunteer mediators for contributing significantly to the success of this initiative. Let me close by highlighting some of the work that we have done this past year and will continue to do to advance the rule of law in the domestic and the international space. I begin with civil justice. As I have mentioned, the Appellate Division of the High Court is now operational and indeed has already received its first filing. This will allow us to utilize our appellate judicial resources more optimally. We can also expect the implementation of the new rules of court later this year, which will modernize our civil justice system. Let me also mention the Insolvency, Restructuring and Dissolution Act 2018, which was brought into force last year. This consolidates and updates Singapore's bankruptcy, corporate insolvency and restructuring laws and aligns them with international best practices, enhancing Singapore's position as an international center for debt restructuring. The simplified debt restructuring and winding up regimes will offer more affordable and efficient methods of restructuring and liquidation, and will be especially important as the pandemic continues to impact commerce. I turn next to family justice, which is now firmly rooted in therapeutic justice, seeking to resolve disputes in a holistic, restorative, and forward-looking manner. Let me mention 5 initiatives we are working on. First, an advisory research council has been established to bring together international thought leaders to share perspectives on therapeutic justice and serve as a resource panel we can consult. Second, the FJC signed a memorandum of understanding with the Institute of Singapore Chartered Accountants last year to establish a panel of financial experts. This will assist family judges with a more objective basis for dividing matrimonial assets. The pilot will commence in the first quarter of this year. Third, I have previously spoken of an online portal which will allow litigants in person to submit court documents using a document repository and connect them with lawyer mediators able to assist them with online negotiations. An online FJC navigation pack and a series of video bites are also being developed as part of this effort to assist court users in understanding and navigating court processes. Fourth, the FJC is working with the Ministry of Social and Family Development to strengthen the maintenance enforcement regime, including by facilitating the service of summonses. And finally, the family justice rules are being revamped and further simplified, with the revised rules expected to be implemented by mid-2022. All of these measures are designed to make family justice less acrimonious, more oriented towards constructive outcomes, and altogether simpler and more accessible to those who must resort to it. I turn next to the Singapore International Commercial Court, which has continued to perform excellently over the past year. Faced with extensive travel restrictions, the SICC led the way in some respects by moving to dispose of substantive matters by live video link. Several SICC cases involved the bench, counsel, and witnesses attending from multiple jurisdictions. In one case, parts of the trial even took place after hours to accommodate the examination of expert witnesses based in Europe and the US. A total of 30 published judgments were issued last year, comprising 25 first instance judgments of the SICC and 5 judgments of the Court of Appeal. The SICC now has a docket of 62 cases, including a recent direct filing concerning a multi-million-dollar claim arising from the international sale and purchase of petroleum products. The SICC's new standard-setting body of procedural rules is also in the final stages of development and will be implemented this year. Let me also briefly mention the outstanding performance of the Singapore International Arbitration Centre, which set a record last year when it crossed the 1,000 case threshold. The SIAC has led the remarkable growth of international arbitration in Singapore, and arbitration is a close partner of the courts in sustaining the rule of law. The SIAC's success bolsters Singapore's position as a center for legal services and an international dispute resolution hub. We have also continued to contribute actively to international conversations and engagements and to deepen our ties with our foreign counterparts. I highlight a few examples. The fourth iteration of the Singapore-China Legal and Judicial Roundtable was conducted by video conference last November. We shared our experiences, exchanged insights, and jointly launched a compendium of international commercial cases from Singapore and China, curated for their relevance to the Belt and Road Initiative. And signaling the strength of our relations, Justice Stephen Chong was appointed to the International Commercial Expert Committee of the Supreme People's Court. We also participated in various virtual meetings, including the meeting of the Council of ASEAN Chief Justices and a bilateral Chief Justices dialogue with our counterparts from South Korea. Looking ahead, the state courts are working to establish an international judicial dispute resolution network, which is a network of judiciaries collaborating to develop frameworks that will promote the early, amicable, and fair resolution of court disputes without trial. This will be done by resorting to judge-led dispute resolution processes, such as judicial mediation, early neutral evaluation, and judge-directed negotiations. I also mentioned last year that we anticipated organizing a symposium on developments in international commercial litigation on the side of the third meeting of the Standing International Forum of Commercial Courts, which we were to have hosted. These events had to be postponed due to the pandemic, but they will be proceeding in March 2021 as virtual events. Let me highlight the SICC Symposium, which has been rescheduled as a live webinar on 10th March 2021 with a distinguished lineup of speakers. There will be in-depth discussions on the forthcoming new SICC rules, emerging trends and opportunities for commercial courts and other dispute resolution options in a post-pandemic world, the enforceability of court judgments and the role of commercial courts in cross-border insolvency disputes. The symposium affords an excellent opportunity to stay abreast of the latest developments in international commercial litigation, and I encourage those of you with an interest to register. Finally, the SJC has continued to engage our international counterparts, including by organizing the Judicial Education Masterclass held in collaboration with the U.S. Federal Judicial Center, and a joint pedagogy seminar with the China National Judges College. The SJC also entered into a landmark memorandum of understanding with the U.S. National Center for State Courts. Our continued participation in foreign exchanges and engagements is a testament to our commitment to the rule of law, both domestically and internationally. They also evince the international community's trust and confidence in the integrity of our institutions and the value ascribed to our contributions to these important discussions. Perhaps the best manifestation of these points can be seen in the work and achievements of the Asian Business Law Institute, or ABLI, established just 5 years ago with the weighty mission of promoting the convergence of commercial laws in Asia. ABLI has punched well beyond its weight in that time. This past year, it partnered the International Insolvency Institute in April and launched Corporate Restructuring and Insolvency in Asia 2020, a compendium of reports examining the corporate restructuring and insolvency regimes in 16 jurisdictions in the Asia-Pacific region. Looking ahead, the ABLI III project aims to make recommendations as to how jurisdictions may collaborate more effectively on in-court and out-of-court workouts. In September, ABLE released the Asian Principles for the Recognition and Enforcement of Foreign Judgments in Asia, the first such publication anywhere in the world. The Asian Principles seek to promote convergence in this area and so to advance the portability of judgments within ASEAN and its major trading partners. In November, the ABLE Data Privacy Project was selected from 850 submissions coming from 115 countries to be presented at the Paris Peace Forum, an annual conference where heads of state, international organizations, top industry leaders, and NGOs meet to construct new forms of collective action regarding global governance issues. And just a couple of days ago, we learned that ABLE's Comparative Analytical Review on Data Transfers Regulations in Asia, that was published last May, has been honored with the Privacy Papers for Policymakers Award by the Future of Privacy Forum, the leading privacy think tank in the US. ABLE's publication has been selected from among dozens of applications as a must-read for policymakers on privacy issues. This is the first time in the 10-year history of the award that a paper focused on Asian laws has been selected, and the team will be presenting its work at an event to be attended by policymakers, privacy professionals, and academics in February. I highlight these achievements because they validate our long-held belief that we do have a significant role to play in advancing multilateralism and the rule of law even beyond our shores, and that it is well worth expending the effort to do anything we can in the law's effort to make things better. I have reached the point in my response where I announced the appointment of senior counsel. The selection committee has decided to appoint as senior counsel this year Mr. Verghese S. Abraham, Ms. Tan Ruyan Christie, and Professor Goh Yi Han. I congratulate each of the appointees and look forward to their continued contributions to the profession. Let me close by thanking all of you in the profession for working with us to administer justice in trying circumstances this past year. The dramatic challenges we all faced have highlighted the importance of our work and also the value to be had when we come together in a spirit of trust and collaboration. We must continue to embrace the spirit as we ready ourselves to seize the opportunities that lie ahead of us. I have every confidence that we will pull together as we have always done to ensure justice for all. Thank you all very much for your presence this morning. On behalf of the judiciary, I wish all of you a happy, healthy, and fulfilling New Year.
Court stands adjourned.
Ladies and gentlemen, we have come to the end of the opening of the legal year 2021 ceremony. Thank you for joining us today. Stay safe and stay healthy.